Hello everyone, welcome to my channel. So we're going to take a look at the Civil Procedure Code 1908, so which specifically talks about the place of sowing, section 15. So yeah, and based on the time, if you wanted to, like, if you have the time permits, then we can look at the section 16 as well. But today we video mainly covers about section 15. So let's see, like, what is the bare definition of section 15 is court in which suits to be instituted. Every suit shall be instituted in the court of the lowest grade competent to try it. So let's take a look at the explanation. So suits should be filed in those courts which has jurisdiction to hear the matter in dispute. So whatever the dispute we are bringing to the court, so should have the jurisdiction. Okay, so there are three types of jurisdiction, like pecuniary jurisdiction, territorial jurisdiction, and the subject matter jurisdiction. Let's take a look at the what pecuniary jurisdiction is all about. So based on the monetary value of the case, so which court will hear the matter? So based on the suit, okay, value. So based on suit value, if the matter is falling under the purview of the junior civil judge or senior civil judge or the district court judge, so the matter is filed before those judges. Okay, so let us take an example of the court, like for Telangana. So a junior civil judge bench can hear the matters up to 10 lakhs, and a senior civil judge can hear the matters like between 10 to 50 lakhs, and the district court can hear the matters above 50 lakhs. Okay, so this is only related to the Telangana. Okay, and let's, we will discuss more, like, particularly about the jurisdictions. So like the pecuniary jurisdiction, and like what is the section 15. So like every suit, like whatever the suit, like if the plaintiff wanted to file before the court, the advocate needs to be filed the case in the court of lowest grade, okay, which is legally competent to hear and decide the case. Okay, and like, which is like very, I just wanted to put it in very simple words, like you cannot directly file a civil court and a higher court if a lower court has the power to handle it. Okay, so you must start the suit in the lowest appropriate court. So what happens is, like, you the civil court will, like, junior civil judge will hear the matters. So if it is under the below the 10 lakhs, as per the Telangana state. Okay, but if someone has lost it and wanted to appeal, then the matter can be sent it to a higher court, wherein they can see, like, based on the pros and cons and the trial matter, if there is any, like, uh, if there is a mistake of law, or like, if the rules have been applied incorrectly, then the higher court will be, like, we will be observing the case and give a decision on based on the pros and cons. Okay, and so we'll see, like, pecuniary jurisdiction is, like, basically is the amount of money involved. Okay, and as I told you, like, there are two more other jurisdictions before filing a case. They need to be also be taken care of, like, before filing a case. So if the court has the territorial jurisdiction, maybe like the location of the dispute, like if it is, like, doesn't fall under the jurisdiction, then probably they cannot hear the case, because the court have the pecuniary jurisdiction but doesn't have a territorial jurisdiction. It cannot hear the case. And also the matters related to subject matter jurisdiction. So it should be the suit should be filed in appropriate court, because if it is a matter of a land dispute, it should be filed in the appropriate court. Okay, not in the rent control act. Okay, so that is above the jurisdiction of the Rent Control Act. Okay, so if it has a, see, the purpose of pecuniary jurisdiction is, like, small value cases go to lower courts, high value cases go to higher courts. So it unnecessarily avoids burdening higher courts with minor suits. Okay, and how exactly this pecuniary jurisdiction works is, like, each court has a maximum financial limit set by state laws, as I discussed earlier. Like, only the junior civil judge can hear the matters up to 10 lakhs for the Telangana state, and a senior civil judge can hear the matters between like 10 lakhs and between 50 lakhs. Okay, and the district judge can hear above 50 lakhs. So this is the standard like pecuniary limit for the Telangana state courts. Okay, and formula to like what happens, like there should be a particular value of the suit which depends upon the plaintiff's valuation, so and also the market value of the property which is physically present, and the amount claimed, so and whatever the relief sought through, like the plaintiff may ask for the injection damages or a recovery. So whichever value is used under this law applies to decide jurisdiction. Okay, so let us take an example. Like suppose like if A is filing a suit for the money suit recovery suit, so on B, so what happens is he will be filing a case under Telangana state. So he'll be filing a case in the junior civil judge court. Okay, not in the senior civil judge court, because it is only, the value is only for 3 lakhs. Okay, and like another suit for, if the suit value is above like 20 lakhs, then it should be filed like it should be filed like in front of the senior civil judge, and any value like of the property is above the 50 lakhs, then it should be filed before the district judge. Okay, and like we have to like take care of some of the important points, because all the three like jurisdictions are very important before filing a suit. Okay, so if it doesn't have any one of them is also like whatever the trial it conducts, the court is void, and whatever the judgment it gives, it is also will be also invalid. Okay, so and the plaintiff valuation cannot be artificially lowered or increased to select a particular court. So it is not based on the whims and fancies of the uh, as per the plaintiff, because or the defendant. So it should be like based upon the this jurisdictions. The suit needs to be filed in the appropriate court. Okay, and let us take a look at the territorial jurisdiction. What it says. Okay, territorial jurisdiction. Courts can hear the cases which falls geographically under its purview. Okay, and what happens is like territorial jurisdiction means which geographical area a civil court has the authority to hear and decide cases. So under CPC, like territorial jurisdiction is mainly covered in sections 15 to 20, because all these sections like, so 15 to 20 which talks about the territorial jurisdiction. Okay, there might be like suits related to immovable property, which is all like section 16. So all the matters related to land disputes, like flat disputes, mortgage and property, or right to collect rent. So all these things falls under section 16. Okay. So what happens is like any land in disputed has must be filed in the court that has jurisdiction to try. So those courts can hear those cases. Okay, and suit for immovable property or compensation. So what happens is this is all about like section 6, section 19. So where the wrong was committed, like where the defendant resides or carries on business, because this is not related to the immovable property. This is like related to mobile property. Those are covered under sections 19. When we go through that, we I will discuss in more in detail about that. So anything which is like other than immovable property, so those suits can be tried at the places of different defendant resides. Okay, or he works for the green gain, or like he or any like cause of action arose. Okay, so yeah, and like if there are like maybe like if there are like multiple defendants, like section 20 also deals with that. So it's maybe filed where any one defendant resides. So you cannot keep on filing the cases like if there are like 10 defendants, we cannot file at every court like uh, which are like geographically located under the purview of some court. Okay, so we cannot file on the every defendant. So it is comfortable and convenience of or not to waste the time of the court. So we have uh, the advocate should be filing the case where one defendant resides. It's okay, like the other defendants can be asked to come to that court and give their statements. Yeah. So when, like, what happens is, like, when parties agree, or like if the parties agree that they wanted to uh, there is a place, like a particular place where they are ready to uh, go for a trial, so they can do it. So it is based on the, like, jurisdiction clause before the suit has actually risen or, like, taken birth, because the both parties were good in terms, and if there is any matter of difference and wanted to go, so they decided before. Yeah. And, like, let's take a look at it, like, what is subject matter jurisdiction. So courts can hear only those cases which are legally empowered to hear with particular subject matter. Okay. So, like, subject matter jurisdiction means the power of the court. So the to hear cases of a particular type or category. So, in other words, what happens is, like, if the court has a territorial and a pecuniary jurisdiction, it cannot hear the case because it is not legally empowered to deal with those kind of matters. Okay. So what determines subject matter jurisdiction is, like, the uh, court power depends on special statutes and the nature of the disputes. Okay. So civil court can only handle those matters which has a, like, general jurisdiction. Okay. It cannot hear all civil cases unless specifically barred. Okay. So family court hears only family disputes like marriage, divorce, and also, like, child custody, maintenance, or, like, adoption, or other things. Okay, rent control act can, like, this courts can hear only those rent and eviction matters. Revenue court can have only revenue matters. Okay, so this is all about, and there are, like, special tribunals, so which can hear only the subject matter of those related to specific, like, subject matter, like DRT will hear only bank loan recovery. Okay, and government service matters are heard by the CAT tribunals. Okay, so this is all about, like, the tribunals. So, and, like, why it's important, why the subject matter jurisdiction is important, because what happens is, if a court lacks subject matter jurisdiction, then the trial which is conducted, so it is invalid, it will be invalid, and judgment is void. So, and appeal cannot cure that effect. If, even though if we are, like, the judgment is given and the plaintiff has won the case, and defendant goes to the, like, and defendant goes there, like, because the subject matter is not there from the very beginning, so he cannot say that, like, we have filed it in the right court, so plaintiff cannot say that. So defendant has every right, he can go and say that it was tried in the wrong court, and yeah, so the case can be restarted again from the beginning. Yeah, yeah, and there are, like, other things, like, there are, like, important provisions, because, see, if the defendant owns or controls the immovable property, and the relief can be given through personal obedience of the defendant. Okay, where the, like, because if the matter is not related to the immovable property, then what happens is, like, wherever the defendant is residing, so we can file the suit under that jurisdiction, and we can try the suit in that particular court. Yeah. So, because this specifically deals, like, it's a property which is in dispute, which is in the falls under the purview of the India. So those, only those like, property disputes can be tried, or else, like, all other foreign properties disputes cannot be tried in Indian civil courts. Yeah, as per this, like, yeah, section 16. So yeah, that is all about the, yeah, section 15. So I will also talk about the section 16 in detail in the next video. Yeah, thank you for watching this video. Yeah, I hope you like it. Please do subscribe. Yeah, thank you.